Hello everyone, welcome back to Legally Dephine and a special welcome to those who have just joined us. This is Legally Dephine where we simplify the law. In this video, we are continuing with our family law in Zimbabwe and we are going to look at the formation of marriages. This shall be a two-part video, but before we start, make sure to subscribe, like and share. Let's get into it. Zimbabwe currently uses the Marriages Act Chapter 5.17. This law came into operation in 2022 and it replaced the old marriage laws, which includes the Marriages Act Chapter 5.11 and Customary Marriages Act Chapter 5.07. For a marriage to be valid in Zimbabwe, certain requirements must be met, the most important of which are consent to marriage and capacity to marry. Capacity means parties must legally qualify to marry. Under the Constitution of Zimbabwe, children do not have the capacity to marry. Section 81 of the Constitution of Zimbabwe defines a child as every boy and girl under the age of 18 years. Section 78 of the Constitution provides that every person who has attained the age of 18 years has the right to found a family. Section 3 of the Marriages Act also provides for the minimum age of marriage as follows. No person under the age of 18 years may contract a marriage or enter into an unregistered customary law marriage or a civil partnership. For the avoidance of any doubt, it is declared that child marriages are prohibited and under no circumstances shall any person contract, solemnize, promote, permit, allow or coerce or aid or abet the contracting, solemnizing, promotion, permitting, allowing or coercion of the marriage, unregistered customary law marriage or civil partnership, or the pledging, promise in marriage or betrothal of a child. Any person other than the child concerned who contravenes subsection 2 shall be guilty of an offense and liable to a fine not exceeding level 10 or to imprisonment for a period not exceeding 5 years or to both such fine and such imprisonment. It shall be an aggravating factor in an offense referred to in subsection 3 that the contravention was by a parent or a person in loco parentis to the child concerned. Section 3 of the Marriages Act is simply saying that you cannot marry off a child, marry a child, help marrying a child or marrying off a child or just even participating, because if you do that, it then becomes a crime. A child, as I have defined earlier, is anyone below the age of 18 years. The issue of child marriages became especially important after the Constitutional Court case of Mudzuru and another versus the Minister of Justice, Legal and Parliamentary Affairs of 2015. In that case, the court ruled that child marriages were unconstitutional. The court ruled that allowing children to get married violated constitutional rights and protections. As a result, girls under the age of 18 years cannot get married. Boys under the age of 18 years cannot marry. And even parental consent cannot legalize such marriages as per Section 3 of the Marriages Act. Take note that the minimum age of marriage applies to all types of marriages, that is, customary marriages, unregistered customary, civil marriages, qualified civil, and even civil partnerships. The word incapacity means lacking the mental or legal ability to do something. But when can we say a person does not have the capacity to marry? The first instance is mental incapacity. Mentally challenged people have absolute incompetence to marry because a person must understand the nature of marriage and must be mentally capable of consenting. If a person is unable to understand or comprehend the nature of the marriage contract they are entering into, the marriage becomes void ab initio, which means it becomes invalid from the beginning. Even if a person is able to appreciate and understand the nature of the marriage contract, but consent is motivated by a delusion caused by a mental illness, that marriage is also invalid from the beginning. The position regarding mental incapacity is the same both under customary law and general law. The second instance is when a person is already in a civil marriage. If a person is already in a civil marriage, they cannot enter into any other marriage of whatever form as long as that marriage still exists. If one does so, it can amount to the criminal offense of bigamy under the Criminal Law Codification and Reform Act. For a more thorough refined explanation, we have covered bigamy in one of our videos here on Legally Dephine Types of Marriages. Go check it out. Instance number 3. Persons of the same sex cannot marry. They do not have the capacity to marry each other. This is in terms of Section 78, subsection 3 of the Constitution, which says that persons of the same sex are prohibited from marrying each other. And finally, persons who are related within a certain degree of affinity are prohibited from marrying each other. The prohibited degrees of relationship are in terms of Section 75, subsection 2 of the Criminal Law Code, and it reads, where sexual intercourse takes place between a parent and his or her natural child, whether born in or out of wedlock, or adopted child, whether the child is under the age of 18 years or not, or a step-parent and his or her stepchild, whether the stepchild's parent and step-parent are married under the Marriage Act, Chapter 5.11, or the Customary Marriages Act, Chapter 5.07, or are parties to an unregistered customary law marriage, and whether or not the child was over the age of 18 years at the time of the marriage, or a brother and sister, whether of war or half-blood, or an uncle and his niece, or a grand-uncle and his grandniece, or an auntie and her nephew, or a grand-aunt and her grandnephew, or a grandparent and his or her grandchild, or subject to subsection 3, any person and his or her first or second cousin, or any person and an ascendant or descendant of his or her spouse or former spouse, whether the person and his or her spouse or former spouse are or were married under the Marriage Act or the Customary Marriages Act, or are or were parties to an unregistered customary law marriage, or any person and his or her ascendant or descendant in any degree, or any person and a descendant of a brother or sister, whether of war or half-blood, and either or both of the parties know or realize that there is a real risk or possibility that they are related to each other in any of the foregoing degrees of relationship, either or both parties to the intercourse, as the case may be, shall be guilty of sexual intercourse within a prohibited degree of relationship and liable to a fine up to or exceeding level 14 or imprisonment for a period not exceeding 5 years or both. Section 7, subsection 1 of the Marriages Act, Chapter 5.17 also prohibits people who are related from marrying each other. The second major requirement to a marriage is consent. Marriage must be entered into freely and voluntarily. That means no force, no threats, and no coercion. Section 26A of the Constitution provides that the state must take appropriate measures to ensure that no marriage is entered into without the free and full consent of the intending spouses. Section 78, subsection 2 of the Constitution further provides that no person may be compelled to enter into a marriage against their will. Section 4 of the Marriages Act also provides that a marriage shall not be solemnized or registered in terms of this act unless each party to the marriage has given his or her free and full consent to the marriage. Therefore, if consent is obtained through duress or fraud, the validity of the marriage can be challenged. Marriage is regarded as a serious legal institution under Zimbabwean law. Therefore, genuine consent is extremely important. Not all marriages are legally valid. Now, we have two words coming into play: void and voidable. They sound the same, but they mean completely different things. Let's begin with the word void. What does the word void mean? The word void means invalid. So, in relation to marriages, we are saying the marriage is simply invalid from the beginning. Examples of void marriages include child marriages, bigamous marriages, same-sex marriages, as well as marriages between persons in relations within the prohibited degree of relationships. So, what do you notice from the examples I've mentioned? You will notice that most of these things which are being called now marriages or invalid marriages are actually criminal violations. For example, let's look at child marriages. You see that a person has married any person who is below the age of 18 years, which is a crime. Bigamous marriage, a person who is in a civil marriage is entered into another marriage, which is a crime. Same-sex marriage, it is a crime under the criminal law code, as well as marrying a person who you are related to. On the other hand, we have the word voidable. What is a voidable marriage? A voidable marriage is a marriage which is valid for all purposes unless and until a decree of annulment have been obtained. In simpler terms, we are saying that a voidable marriage remains valid until a court sets it aside. So as long as a court has not set it aside, children born in that marriage remain legitimate. Parties can inherit from each other. The reciprocal duty of maintenance continues, and wife can assume husband's domicile. Examples of voidable marriages include where the marriage was a result of fraud, intimidation, or coercion by fear or duress, where one party suffers from permanent impotence, where the woman is pregnant at the time of marriage by someone else through illicit intercourse and husband is unaware of this, and where either party is at the time of marriage mentally challenged within the meaning of the Mental Health Act. A voidable marriage does not involve the following: child marriages, bigamous marriages, same-sex marriages, as well as marriages between persons in relations within the prohibited degrees of relationships. This means that in the face of the law, the marriage is valid. The voidable part comes due to the fact that maybe consent was not obtained by willful means, or a person was simply just forced into the marriage, and that will make it a voidable marriage. If parties to a voidable marriage are agreeing to their marriage or upholding it, that marriage is formally approved so that it becomes legally valid and binding. However, if a part to a voidable marriage is aggrieved, that aggrieved party can bring an action to the court. The action for a voidable marriage can only be brought during lifetime or in the time when all the spouses are still alive, unlike for a void marriage where action can still be brought even after death. For a voidable marriage, death kills the action because an annulment is a remedy that ends a marriage which exists. Once one spouse dies, the marriage ends automatically and is treated as valid for inheritance and status purposes. The surviving spouse can claim as a spouse unless the marriage was declared voidable while both were still alive. Therefore, the distinction between void and voidable marriages is very important because legal consequences differ depending on whether the marriage is void or is voidable. That wraps it up for today, and void, voidable, consent, capacity. It was a lot that we covered in this video, and if you have any way to explain anything better, please share in the comment section, engage, like, subscribe, and share. See you on the next one.